In this subunit, we're going to talk about two more provisions of the Statute of Frauds, the land provision and the guarantee provision. Once again, here is our mnemonic device to help us remember what types of contracts are within the Statute of Frauds: marriage, year, land, executor, guarantee, and sale. So we have already talked about marriage and executor. We will later talk about the 1-year provision and the sale provision. Let's now focus on the land provision and the guarantee provision. Contracts for the sale of an interest in land, and what we mean here by land is real estate, must be in writing. These types of contracts are within the Statute of Frauds. As you go on in your law school career, you will take Property 1 and Property 2, and you will learn that under the common law, there are many different types of interest in land. And so I give 3 examples here. There's the fee simple. If I transfer ownership of land to you outright, then it is a fee simple. I could also transfer ownership of a land to you for your life. That is a life estate, meaning when you pass away, the land is no longer part of your estate. It's no longer yours. Or I could transfer a future interest in land to you. I can say, listen, right now I'm transferring a life estate to Bob. When Bob passes away, you get the land in fee simple. And then that is a future interest. Don't worry about all the different types of interest in real estate or land right now. You will learn those when you take Property 1 and Property 2. For now, you should just understand that any type of interest in real estate, if there's a contract for the transfer of any type of interest in real estate, then that contract is within the Statute of Frauds and it must be in writing. If it's not in writing, it's not enforceable. All right, there's an interesting question under the land provision. Is a lease of real estate an interest in land, or is it a contract? Under the common law, a leasehold, we call it a leasehold, is an interest in land. But the common law is kind of schizophrenic about this. Sometimes they consider a lease of real property, right, an apartment or land. The common law considers it to be a contract. So we kind of have this dual nature of a lease in land. It might be an interest in land, and it might be a contract. There are 2 ways that Statute of Fraud provisions deal with this. Some of them are silent on it. Okay, so there are 3 ways. Some Statute of Frauds provisions might be silent on the matter. Some statutes might flat out say that a lease of an interest in real property is within the Statute of Frauds. In other words, it must be in writing. Some other statutes will say a lease of an interest in real property for 1 year or more, or let's say more than 1 year, not 1 year or more than 1 year. That's typically what I'm saying, is within the Statute of Frauds. So a lease of a lease of an interest in real property in these jurisdictions is only within the Statute of Frauds. In other words, it only is required to be in writing if it's for more than a year. Let's talk about our next provision in the Statute of Frauds, the guarantee provision. Remember what a guarantee is. A guarantee is where you promise to answer for the debts of another. We talked about this when we talked about unilateral contracts. We said this was traditionally one of those unilateral contracts, or another way we phrased it was a promise seeking performance, right? So now I make this promise to a bank. If bank, you lend money to the borrower, I will guarantee the debt. I'm acting as a guarantor. This is a guarantee promise. It must be in writing. If it's not in writing, it won't be enforceable. This type of promise is within the Statute of Frauds. So in this case, if we look at the fact pattern, we have the borrower. The borrower is the primary obligor. That contract between bank and borrower is not within the Statute of Frauds, right? There is no provision that we've run into so far that would say that that contract has to be within the Statute of Frauds. But my contract with the bank, where I promise to act as a guarantor, I am not the primary obligor. I am the guarantor. I'm acting as a secondary obligor. That contract is within the statute of frauds, and it must be in writing. If it's not in writing, it won't be enforceable. Here's some things that students sometimes get confused. You might co-sign a loan with somebody. So sometimes you see parents co-sign loans with their children, or spouses might co-sign loans. When you co-sign a loan, you are acting as the primary obligor. You have co-primary obligors. You have two borrowers when the parent and the child co-sign a loan. That is not a guarantee. So that type of contract is not required to be within the statute, is not within the statute of frauds, and so it does not have to be in writing. But if you're signing something, if you're acting as a co-signer, then you're signing something, so it's probably written anyway. Let's continue talking about the guarantee provision of the statute of frauds. Now, there is one specific fact pattern where courts will say, even though it looks like a guarantee, it is not a guarantee. And that is a situation where the putative, the purported guarantor is making the promise, making the quote-unquote guarantee promise for her own benefit. If she's making the promise for her own benefit, then she is not a guarantor for the purposes of the statute of frauds, right? Not for the purposes of determining whether this is a unilateral contract or whether it's a promise seeking performance. Here's an example. So when a parent company guarantees the debts of its wholly owned subsidiary, that is not a guarantee for the purposes of the statute of fraud. In other words, the parent is guaranteeing the debt of its subsidiary company for its own benefit, right? For the parent's own benefit. And therefore, it's not a guarantee for the purposes of the statute of frauds. In other words, it does not need to be in writing. Here's another example. We have a customer and supplier, and customer needs to get the goods from the supplier, but the supplier cannot get the goods itself. And so the customer guarantees the supplier's obligations. Why? So that customer can get the goods she needs. So even though it seems like she's acting as a guarantor, this type of guarantee is not within the statute of frauds. In other words, this type of guarantee does not need to be in writing. Look for these fact patterns, right? How a court will actually decide in these situations is difficult to say, but look for these situations, look for these fact patterns, and hopefully a red flag will go up and you say, I need to talk about this, I need to investigate this, I need to research this.